And Tim, preliminary matters, additions, and agenda additions and deletions.
Mr. Chairman, the staff has no additions.
Board members have any?
No.
Mr. Cahoy, would you come and sit over here for me? That way I'll be able to get attention easier. Our first item then is the approval of the minutes from the December 4th meeting.
I do have a question on that.
Sorry.
I remember that I had made some inquiry about the loading zones and the dumpster, and they're not included in the minutes. They should be somewhere about after the public hearing was closed at 2:23. That's on page 4. Mr. Cahoy had asked about the noise issue with the residential community over there, and it was in that area, I know, where I had asked about questions with the loading zone and the solid waste, and was assured that there was no problem. So I would like to have that included into the minutes.
Would you review with me exactly what the correction we need to do there is?
Okay, on page 4.
Yes.
About halfway down.
Okay.
I believe it was before Mr. Cahoy asked about the noise issue with the residents.
Okay.
I asked about the ability for the trucks to come in and out on the loading and also the solid waste, and was assured that there was no problem with that they were really in compliance. So,
Anybody object to that correction?
No, I remember that.
Okay, then can we add it?
Yes.
Thank you very much.
thank you. So with that amended, I'd like to approve, we move we approve the minutes.
It's been so moved. Do I have a second?
I'll second.
It's been second. All in favor?
Aye.
Opposed? The next item on the agenda today is the we have open public comment right now. So I will now open it for public comment. Seeing nobody coming forward, I will close public comment. And we will now have a public hearing, and I'll read that to you. A public hearing on the ordinance amending Chapter 60, General Provisions and Appendix Definitions of the Land Development Regulation to provide clarification and updating of certain text and definitions. Tim, would you like to lead that for us, please?
Yes, sir. And before I go over the proposed draft ordinance, I'd like to give you a quick background on how we got to where we are, because this is kind of out of the ordinary how this was done. And I'm sure you all have some questions. After the review of the recent court decision regarding our vacation rental appeal, it was the general consensus of our legal staff and outside counsel that the District Court of Appeals ruling was narrowly based on the authority of the Code Enforcement Board to interpret the city code. It was not based necessarily on the merits of the city's position regarding a prohibition against vacation rentals, nor did it invalidate the city's historical prohibition of vacation rentals in residential zoning districts. So I think that's something we started with, that understanding. The city's moving forward to address the issue of the Code Enforcement Board. They're making, there's been a draft ordinance provided the city attorney to amend it to basically remove any misinterpretation that they have, any interpretation ability that they do findings of fact based on whether it's a violation or not. The violation itself and how the code's interpreted is by the respective either the authority or the Planning and Zoning Board or the City Council or the planning director. So that takes care of that issue. And then we hope that cleans that up so we don't have that problem again. With that being the issue addressed, the City Council indicated its strong intention to vigorously enforce the vacation rental prohibition. Before directing staff to do so, the City Attorney recommended the Council that the existing regulations be tweaked to clarify and make more transparent the City's historical prohibition on vacation rentals. To expedite the matters, the Council directed staff for a draft ordinance for first reading before it could be sent before the normal hearing process, which requires a public hearing before you all, and that was done that way. And so, but they understood The council at the first reading, which on December 2nd, were informed that that the ordinance itself would have to come back through you all, and they understood that there would probably be more revisions to this ordinance based on not only our council looking at it, but outside council, because we quickly had to get to, but also what could transpire out of the meeting, the public hearing that we're having today. The staff also cautioned, as I said, they expect revision. So the ordinance that you're seeing today is already different than the one that the council said. There have been changes done to that. In preparing the draft ordinance, the primary emphasis was on clarifying the city's vacation rental prohibition. However, it was also decided to address some other minor issues in the code dealing with administration of zoning, map, and some definitions needing clarification updating. So you see there are other revisions in there, but basically we were under the direction of the council to prepare an ordinance to deal with clarify the vacation rental ordinance. The draft ordinance before you is the 8th version of our ordinance. So this tells you we've been going through over the last few weeks a lot of different changes on this. The primary concern has been to ensure that the amendments pertaining to the vacation rentals don't go beyond the city's historical interpretation and application of the code that was enforced prior to June 1, 2011. If you all recall, that's the date, the vesting date that the state did when they preempted local governments from regulating, or the duration particularly, of vacation rentals. Our real concern is, is that the city doesn't want to lose its vesting. We don't want to do anything that would jeopardize the vesting of our ordinance that somebody would call into question if we were to expand it. Based on a webinar that we had on Wednesday, the Florida League of Cities put a webinar on, we got a little more conservative in our approach. So the city attorney and I looked at it. I think Peggy looked at it, but Mr. Comment and I looked at it, and basically we felt that we need a couple more revisions to the ordinance. I'm going to go over those today. So again, we're trying to be very cautious on this. We feel we have a good ordinance, that it didn't get played fairly out at that hearing, but we want to be sure that we haven't done anything here. So that's why we've been second guessing and going back. But after that hearing, there was concerns for a lot of communities are in the same boat we are, to not do anything that would jeopardize their vesting. A lot of other communities that aren't vested, or not trying to claim vested, are going through preparing regulations to deal with these. They can't deal with the duration, but there are a lot of the impacts they can. And even they are a little concerned because, as was pointed out, the vacation rental industry and their lobbyists are really still moving at this. In fact, they are moving to make more changes in the legislation, even though the League of Cities and other allied groups are trying to protect the cities and their home rule powers in this case. We've already seen a bill that was recently introduced that basically is going to take state regulation of vacation rentals away. They won't be licensed under the state. That makes it even more difficult to track these things down. So what we've tried to do is a very conservative approach that's basically in line of my opinion letter that I drafted in June of 2011, as well as the Florida statutes and their definitions, and that's how we generally followed this thing. What I'm going to do before I start, I'm going to hand out the substantive changes I've done that we're recommending, so you have them in front of you, and I'll go through it as we go down. So please.
Can I clarify a couple of things for you before you?
Please.
Number one, what we have in front of us is not, we'll have something newer in front of us. What we reviewed, we'll have something different in front of us.
Right.
Not substantial change, but just some minor changes.
Right. I'm going to do I've got substantial changes.
Okay.
I'm showing you, okay, that we'll go over. But we're also going to do some minor editing, and I didn't give you all those because there's not a substantive change. It's more of, I think it should be worded this way or that way, and I didn't think if I brought all those kind of little minor things to you, I think you would get lost in it. But we're not going to ask any changes, going to have any substantive changes,
Tim,
as far as I can tell you.
Yeah, my big concern is on some of the wording, and as we go along here, I'm wondering if
that's fine. I have no problem with that. Okay.
Well, just say yea or nay.
And we want your input. So if there's some things you would like to see change, that's fine. Okay. I'm not trying to preclude that. I'm just saying there's some other minor edits in there that we're looking at probably making that don't really change anything, but it just makes it read better or more clear. more clear. So, but I certainly would be, anything you have an input on it, we will certainly take that into.
Just questions.
Yeah, no, that's fine.
If there's been 8 renditions of this so far, do they have to go through the first reading again if it's changed?
No,
No.
Their reading they had as part of City Council is still in effect?
Right.
Even if there's major modifications to it?
Well,
Yes, as long as it sticks to the same general subject matter as before, it's fine.
That's the point of...
Case law
Okay.
says that.
Okay.
yeah, and that's basically it is, and we're not trying, if we had to, they would go back to, it'd be first reading again. All right, so I'm going to hand this out to y'all.
Okay.
And so just bear with me as I go through this. I don't like getting into this, but this was a last-minute thing Wednesday. And we're very... Should have
Yeah, because I haven't seen it either.
No, I know you haven't.
It was very interesting at that webinar that we listened to on Wednesday. The county attorney for Flagler County, they've had a terrible time in Flagler County, and they had nothing in place as of June 2011, so they're starting from scratch. And also Susan Trevarthen did a presentation too, but they made one thing clear that I thought was really interesting. They said that the way it was done by the legislature in 2011 was the decision was made so late in the legislative session that the people who didn't have anything in place, like Flagler County, had absolutely no time to go through Planning and Zoning Board, City Council first reading and second reading. And the people who had something in place, like we did, didn't feel like we had enough time to make changes that might rock our grandfathering status. So not a lot of changes were made, and people were kind of stuck in that cement where they were. So it was a very good webinar, I thought.
I remember that council meeting where the council decided we won't do anything to change what we've got. Yeah.
Okay, Mr. Chairman, unless there's some other questions of what I just went over, I like to just start down through the ordinance and and why don't we just go down through each section and bring up your comments and I'll answer questions. Is that all right?
Everybody's okay? Sure.
Okay. Our first one is section 60.05, and basically all this does is clarify what our zoning districts are. Our ordinance, nobody bothered to amend it to get it up to date all these years, so I just went through and we just changed everything to come into what is existing ordinance in place. One of the things I'm intending to do in the future is why I have the multifamily all together is I think we're going to come up with one section, one whole chapter or section for multifamily, like similar to single family. What has happened?
I agree.
You got too many conflicts. There's words missing. If you look at it, it just drives you nuts. So it'd be cleaner for people, and most of the stuff is the same regulations. So it would be a lot easier for everybody to see that.
Is it a formatting change, or there's no substantive change then, you don't think?
Well, there'll be some substantive change because we have to clean up some errors that are done in there. There are a couple of places I couldn't even understand what it means.
Okay.
So if I can't understand what it means, there's some real problems in it. Okay? So anyway, unless you have some questions, that's basically what we did in that, just to clean that up. Okay, 60.06. This is where we got, our ordinance is normally any law or a zoning ordinance is basically what the powers of what the scope is. If it isn't listed as one of those, it's generally forbidden or prohibited. Our ordinance is based on that. It doesn't say that in the ordinance. In fact, you'll see places that said this use is prohibited. One of the things our outside counsel did, and Mr. Comet and I also wanted to do, was expressly state, unless it's listed as a permitted or conditional use or a special use in that district, it's not allowed. So there's no question about that. And that clarifies that, and that's what that language in A
So I have a question about that.
Yes, go ahead.
Is that an historical change? By that I mean...
No, that's how our ordinance is interpreted. Based on the common zoning or any kind of, and Peggy's the attorney, so she can give you, I forgot what the Latin phrase is for this, but anyway, basically, if it's not expressly allowed or permitted or scoped, then it's not, it's something that can't be done or prohibited in that, and that's, so we wanted to make it clear in the ordinance that, so if somebody brings that up at some time.
I mean, that's really the crux of this big change that we're making.
Well, it's not a big change. I mean, basically, we've had that. That is the defense we had, and the big advantage we had over a lot of other communities that try to claim they had the vesting is that we have the guest quarters and transit, or guest house and transit quarters, which is clearly a temporary or transit use. That was a use. There was a definition for it, and it was never allowed. You didn't see that in any of the residential districts. So that's one of our major if we didn't have that in there, we'd probably have some real issues.
Okay.
And that's what our feeling was. It was very strong. That never came up in any of this discussion, as I said, in the appeal case. That was not, but it did come up when we did the code enforcement, before the code enforcement board. It was very clear that is a use. It was defined that way. So, we've rested on that, and this just goes ahead and puts it in, it codifies what it is for the average person out there, so there's nobody can bring up that. We also, expanded on the planning director should determine writing. That's what I normally, this planning director has the authority to interpret the code. This just goes into a little more that the planning director is allowed to, has that authority to interpret the code. We have uses that come in. The one thing of our ordinance, it's a very permissive in that we don't go into, see, if you look at the county ordinance, they'll go into detail on like 15 or 20 different retail uses. Our ordinance is not that way. Ours is much more flexible, but there are uses that come in that sometimes you have to make an opinion on because it isn't as clear. So you go, that's what the planning director, that's the job of the planning director. But the planning director also, we have ability of the planning director to consult with you all to get some guidance on, does that make some sense? And that or the city council. And we put that in there.
Tim, when we go into the actual ordinance as it's written,
yes.
Are we going to follow that up here, or do you want me to address my question now?
Oh, no, go ahead and address it right now. That's fine.
Okay. It says that the guides that will be used on making decisions are two publications. One was the American Planning Association, the other North American Industry Classification. Are these publications compatible, or are there some philosophical differences that could create a bias?
No. The American Planning Association worked closely on the other standard.
Okay.
I mean, they're the well-known, recognized planning, and they do a lot of data work. So all this was coordinated on this.
Okay.
And the idea of having these two, because there's different detail in each of them, and it helps you. You may have to look at different characteristics to come up with, is that use similar to this use in that district?
Okay.
All right.
Good. Thank you.
Are we okay now, and you want me to? I'm looking at it, just checking. All right, the next one, the boundaries of the districts, it's kind of redundant. We just threw that out. So I put it reserved because we'd have to renumber everything, and it's just okay, the official zoning map. We've never really followed this very well, so I decided let's go and do it the way it should be done. And basically is that the official zoning map, if you ever come into my office, you'll see we have a map up on the wall. It's the official zoning map. It has the clerk certifying to it. It has my signature and the date. So that is the official zoning map, and this codifies what we've been doing in practice.
You update that like the last modification?
Yes, we do that.
Added new areas.
Right, we do. In fact, I think I had did I have any days to update it? I forgot. We have to go through
the public also.
There's 5 days. Yeah, we have to go through GIS, so it's usually around 5 days to get it. And our GIS map before GIS took over, our map didn't follow the GIS, so it had some problems. So we took care of that. The GIS map is very good at and has all the parcel data in there. So it's all parcel based, so we've got a very accurate zoning map now. Let's see. And we do retain a register. So we have a register of all the zoning changes that have been made officially. So you can to keep track of all that. So it's pretty straightforward, but those are good procedures and good public records keeping for this. All right. And now we get into probably the meat of what we're talking about today, would be the definitions. And as I said, we're going to have some definitions in here not related to vacation rental. We're going to have some that are. And I'll also bring up why we brought up a few changes in this. I didn't have a lot of time when I prepared my staff paper to you, so I would have gone in a little more detail at times, so I figured I could follow up in these meetings and answer any questions if I had to on that. The first had to be on an accessory structure and use. This basically, the wording that we had in there is to really just follow up that we do allow accessory uses on other property in certain circumstances. Parking is probably the major one. Okay, and the way the ordinance read, parking is an accessory customary to most uses, unless it's a standalone parking lot that has no principal use. It's there, for instance, like, such as a public parking lot is a standalone lot. Okay. The agreed person, that was changed, and I'm going through every one of them because you may have questions that I didn't. All right. The agreed person is this recognizes what we're talking about. The way the code was reading it was just by zoning, but there's more than that, or quasi-judicial that may be affected to be an agreed person. So we just changed the language in that.
The language does, on the copy that we were forwarded, must exceed in degree the general interest. How is that measurable, exceed in degree?
Well, in reality, Peggy, am I wrong? Let's put it this way. If somebody files an appeal or something, they'll hear the appeal. I mean, we've discussed whether you should have a pre-hearing to determine whether you've got standing or not, and I think the city attorney said, no, we're not going to do that. It's like getting through the issue with, should we have a de novo hearing, or should we have by a records hearing? And our hearings are de novo when they go to the city council. It just was too difficult for the average person to understand all that.
Right. We try to be a little flexible.
Yeah.
They get their day.
Yeah, they get their day. And we try to make it's like $600 to $800. It's not like chump change for somebody, so you don't see a lot of appeals being done without somebody really having some interest in it. Okay, we also came up with a new definition, allowable use, because that fits back into the other portion when we talk about allowable uses in the district. So we spell out what they are. I mean, this just clarifies the ordinance for the average person reading it would understand that. Next is building. We just added some language about a roof in that. It's not really anything big deal, just cleaned it up a little.
A question on what is the definition of a shed or open shed?
Well, an open shed wouldn't be enclosed. Okay,
I was just wondering.
Now, everything, you can come to a point where you can over-define everything.
Oh, I know.
In here. So, I mean,
I don't want the loopholes, though. That's
we don't usually. It's hard for people on those kind of things. I know what you're saying. I mean, there'll be cases where we feel we need to have a definition. Other cases we don't.
Do we even need to put that in there then if we're not going to define it?
No, because we have a lot of words we're not going to define. I mean, there's going to be some common logic. If not, we always fall back on the dictionary or fall back on, all right. And I've not had a problem. What I try to do here is pick out things that we're having issues with rather than getting into. I've never had any problem.
I'm looking to prevent them. That's all.
Yeah, well, we just haven't had that. It doesn't mean in the best of all possible worlds we couldn't have more definitions, but it does kind of drag down an ordinance. All right. The next is commercial amusements, and this is we've just expanded a little on it. We've added in that it's a use also. A lot of our ordinance, if you look at what we had for definitions of uses, it was more of structures. And it's really both the structure and the use of it. It's not necessarily, form or use are two different. They're interrelated at times. So you'll see we put language in throughout here in that, and I can go into that. The one thing about commercial amusements, and we haven't got into that, has to do with public assembly. This is and that's been brought up by outside counsel, churches and all those kind of things, theaters, are all public assembly. The problem is our ordinances, we treat them differently because we have churches that are allowed in residential neighborhoods. Someday we're going to have to address the issue in a way that meets both the federal constitutional law as well as our own ordinance and balance the rights. I didn't want to take that on right now because that'd be too complicated to do that, but you can see what I mean. We'd be allowing,
Sure.
there's a point that you would be allowing these type of uses, whether they're for profit or not, right in the residential neighborhoods, and we're holding off on getting into that. There are ways to handle that, but we haven't had time to look at it. So we haven't touched that. But we did do some more definition on what commercial
Along
amusements
that
are.
line, then, how would you define temporary commercial amusement? I mean, I was trying to come into my mind saying,
Well,
well, you got
temporary
a bounce
would be
house.
short-term duration. You could run to we did get into temporary more when we get to vacation rentals, okay? But again, you can always follow. Temporary has a very strict, a definition in the dictionary. It's not a full term. Temporary, and normally when we give out permits, if it's temporary, it's going to say temporary. And it's usually a length of period
As a
of time.
time parameter.
Okay, so
Yes.
they need to be permitted, and that's,
Oh, yes, they get permits.
Yes, we
You'll
have
see that.
temporary license agreements, depending on how long
Okay,
the
so-
individual
Depends how it's
wants.
They have
Yeah.
time limits on them.
Right.
So that
good,
covers you
so
there.
that's great, because,
Yeah.
so the provision is understood here that there will be licensing then which will govern.
Yes, I mean, almost everything you do on your property from a zoning standpoint, and when I say out of the ordinary, for instance, you have a commercial establishments, they want to hold a special event with tents and stuff, they get a permit. It's a temporary permit. They have to go make all, check fire, the police is involved, depending on how large it is. And we have duration limits on what they have to do. So, yes.
I was just trying to think ahead.
No, that's all right.
What would happen with, a vacation rental, temporary, just look at
Well, I think we can answer your question when we get further down.
the... Okay, good.
I'll try to answer your question further down. Okay, the conditional use, we just added some more language in there, just to clean it up. It really doesn't change anything. We're always wordsmithing, and with Mr. Comment, we're always wordsmithing. It's always some way to write it. Cultural or civic activities, I just added history. No big deal, in that, but you do have some historical things. Daycare services. Now, this is something that was important because we get into problems where daycare is a conditional use in some residential neighborhoods, okay? But if it's less than 5 children, they're really kind of exempt. You could do daycare at your house. But over that, then you get into the regulatory scheme.
You're not there's 4 children or 5 children, you're not regulated.
No,
It's
you're
like
not
having
under that.
And you can charge a fee to do that, and there's no permit, no regulation.
No,
on it.
there's not. That's in the state. So that exempts, but
Okay.
the thing we get when we're doing permitting, and I'm going to get to it very shortly, you'll understand where I'm coming here, I hope, is somebody's running a system where kids are showing up and all that. We're going to get complaints. We have to make a decision. Wait a minute, did they get a permit? One, can they do this? Did they get a permit to do it? And I've got an example I can go over, which I'll show you in just a second. So this differentiates. So when somebody we get a complaint, well, they got 4 kids over there or 5 kids. No, they don't need. That's all right in the district. They're not regulated that way. When you start getting over that number, then
And this only pertains to children
yes.
of a certain age?
Right.
So
Not
this-
adults?
Well, it could be adults. I mean, we never had that, that issue.
That's a good question.
Yeah, that's a good
Yeah.
question.
That's what I thought.
Yeah.
I mean, if it's
Well, we could put adults in there. I don't have a problem, but our daycare thing is in Child and Family Services. Most of the daycare is all children. There are
you
adult
could run into the
daycare
same
centers.
state issues at some
Yeah.
point in time. You
What about using the word persons?
Well, we could do that. I mean, I don't really have a problem with making that
You
change.
might want to check the statute.
But I'll have to
see.
check the statute.
Yeah.
Doesn't.
What is the definition
I
of
think that
family
the Florida
daycare home?
statutes, I don't believe it gets into adults, but I will check. I will look at that. If it does, if it just pertains to children, then I think we need to leave it the way it is.
But don't
Peggy's
you
correct.
believe the daycare does go into adult daycare just as well as children's daycare?
I know, but again, am I really going to go after somebody that
No,
has
I
3
don't-
adults
I
showing up at the
understand that.
house?
Yeah, but if it becomes a
after that,
problem,
there is a
then
daycare issue. Okay?
Yeah.
And okay. So I'll just review that. I don't know the answer off the top. I've just not had that issue come up. That's why I didn't.
We've had experience with someone challenging by reading between the lines to their favor.
That's right.
And to this specific point, I think your help in reviewing that would be helpful.
Okay, well, I'll take a close look at that and see, if we need to do something. You just have to, I'll work, Wayne and I will take a look at it, or Peggy, and if we need to, we'll put some language in to take care. Okay? Yeah.
And the state specifically states 5 or less, it can't be like...
Well, this is with children. That's why I have to look specifically at the statutes and how that's written, okay? Yeah, but it does state that in the statutes, but I believe it had to do just with children. I don't think it got into adults.
I think we'd have a hard time distinguishing between having guests over every day.
We would.
And say there was 6 of them.
Yeah.
You have a hard time distinguishing those 6 guests coming just as guests. I guess when they start paying you, I think that is the answer.
And licensing, but that's...
Well, licensing's different, and we'll get into that. That's part of what I was going to bring up in an example on the licensing, all right? And in fact, okay, the next one is duplex, and again, the residential use of the building. Again, our thing, again, was all towards form or structure. It didn't get into what the use of the building was. This just cleans that up. And we do that for all, both multifamily and single family. Now, here we go, family daycare home. This is what's in the Florida statutes, and basically exempts these that are licensed by the Department of Children and Families from, they're exempt from, they can be in any kind of residential district if they're licensed under that. What we got into, there is another classification called large family daycare home. I had a daycare, and so we looked at that as the dividing line before the conditional use kind of daycare, where you had to meet. If you're in a residential area where there were conditional uses, that was the dividing line. Well, we had to use a family daycare that was upgraded by the state to a large, and we were getting complaints suddenly. So we worked it out. Actually, I worked with the state on it, so they understood where we on that. When I said they get to a large, then we have, unless they're in some sort of district that allows it by right, they're a conditional use. They have to go through approvals on that, as well as they may have to go through approvals for building code. There's other things involved here.
So has the word large been defined then?
It doesn't have to.
By the state, I'm talking.
Yeah, the state defines it. Yeah,
it did.
Yeah. The state defines it. So that's the cutoff we use when you're on looking at daycare. And what happened to this woman that owned this place, that she had a lot that she could not get conditional use for. It was too small. We require 15,000 square feet and all that. So we entered into a compliance with her, and she got a downgrade to just family daycare. I mean, she'd been working on this, but I said, either that, you got to move. You can't stay there. So we worked with her, and that's how we did it. So those are the things that come up, and you have to deal with it. And that was a troublesome. That's why we put that in there. Okay, the next is the floor area. And before we go into floor area, if you look, I made a slight change in the floor area. And let me get to explain what the problem we had with floor area. Okay. Under our ordinance, the current ordinance, we had floor area ratio is defined by taking the gross floor area divided by the building with the lot itself, the amount of lot. The problem is we have language in here that says that floor area has a different definition, but it's not used in floor area ratio. So that's, the question was brought up. That's why it's confusing. Yeah. So that's why we got into situations on, there were no exemptions from that. If it was enclosed by more than 50% perimeter and had a roof on it, we consider that floor area. And because that's the way our ordinance read. But you would be confused if you read our ordinance the way it is. So we try to clean it up to get rid of the gross floor area, because it really doesn't come into play in the code, and just deal with floor area, and we defined it. However, one of the things we've done here is that we're proposing, if you look at the language I have, and this is up that I provided you, is the first one, is it gets into our current definition of how we measure it, the exterior, but it excludes hotel, motel, room balconies, okay? That's a problematic area for us to check on. And then open and screen porches, patios, outside loggias, and other similar outdoor structure are part of a residential building. What we get into is all these machinations trying to figure out, is that floor area? People are moving roofs around. It's driving the staff nuts. It's driving the developer and the architects nuts, and it doesn't really add to the size of the building at all. And we just felt it's much easier, straightforward, to just exempt those things because they're usually very small anyway. You're not talking about, especially in a residential, and the balconies of hotels are no big deal. It'd make it much easier to administer the code, and we don't think it'll add, it doesn't detract from what we were trying to do with the floor area ratio.
I'd like to go back, before we had excluded garages, now you're including.
No, you remember?
I know we talked about that.
No,
but I don't have that right.
but no, what I said is, the problem is, floor area excluded garages, but floor area was not used in the floor area ratio, which is the
Okay.
That's why we got, no, it's all right.
Okay, I got it.
Well, when you and I talked
Yeah.
on the phone about that, I suddenly had to look back on that, and I forgot that was a brain freeze right there. But that's the problem,
Okay,
is the gross floor area was
I
involved.
think
Okay?
I just got it, okay.
Yeah.
Because I'm still going to bring questions about.
Well, you should see the arguments we go through, trying to figure that out at the office, It is, and it just, it really, and then you'll have an architect, well, this makes crappy design, or I shouldn't use that word, I'm sorry.
Yeah.
Shall we say poor design, pedestrian design. So, we didn't think it was that. It would really save a lot of time, and I don't think it's going to detract from the floor area is not going to be an issue on that thing, so.
Yeah, a question about that, Tim.
Yes.
This is finished first floor elevation, or is this
No, this is the entire building.
entire building?
Yes, the entire building we get into, yes.
All floors.
Yep.
Okay. And then the floor area ratio, you can see, well, we had floor area ration in the code. That's, and again, we said the quotient of the total floor area. See, we got rid of the gross, and that's how, so we put it all together and got rid of that terminology, and that makes it very clear, I think. A lot more clear than it has been. The next one is one, we're now getting the vacation rentals. This is the guest house and transit quarters. As we point out in the code, the words "and" is missing, and that was when they codified it. It was in the original ordinance, but when they codified it, somebody left out the "and." So we put that back in there. This is one of we fell back. We had the definition you see in the draft ordinance. We've fallen back to, if you look at number 2, this is our suggested revision. It's a lot less draconian you see there because we were a little concerned that we were moving too far. So if you look at number 2 on the sheet I handed, that's our recommended language for that. And we debated this, so we don't know what the. I mean, it's just one of those things. I felt
this one a good bit. We bannered this a good bit. I remember this was where you kind of separated the groups, and they're right here.
Yeah. And you'll see now as we go further into this that, okay, on the next definition is guests. See, now we're defining the terms that we use in that, and that's the term the guest, we have a definition for what that is. Now, that makes that pretty clear what a guest is.
Should we add renter to that?
Well, I think if you get down to, it says advertise a place with fewer than 10 with real, or provide for compensation for transits for their temporary care. We get down further, you'll see where we do transit occupancy, transit. We're not, okay?
Yeah,
we'll get down later.
in the first-
You got to look at all, and we tried to pick out terms that but we didn't want to go too far. That's why you see us falling back and deleting some stuff. So I'll get to hotel, motel. We clean that up. The second paragraph, it doesn't mean anything, so I got rid of that. And we just cleaned up the hotel, motel. Occupancy, if you look, we're suggesting we want to delete that term.
Tim,
yeah.
Could we just go back to
Sure.
The guest house and transit
Yes.
quarters? In the copy that we received, you had added dwelling units used, advertised, or maintained as a
Right.
place, and now you're eliminating that?
Because we felt that was going too far. We didn't want to deal with that definition. And I'll take the opinion of our city attorney that,
Okay,
I
because
have
that was
to
a big-
rely on.
Offended?
That is a big
I mean,
thing
we
out
had,
there.
it's, I tell you, that webinar got us a little concerned. We really didn't want to go too far. Now, whether this is, but, he felt more comfortable going that route, so I didn't have a problem because we have other definitions that expand on it, so it's kind of clear on that.
Okay.
Okay.
The reason I'm saying that is because the people out there whose lives have really been turned upside down because of these short-term rentals will point very easily to the fact that they're advertised all over, on the internet in particular.
Well, no. If you look at transit occupancy, you're going to get into it. See, we go into detail in there.
Okay.
Yeah, okay,
So
it's supposed
someone
to all
trying
work
to
together.
defend themselves couldn't just point at one thing and say, well, you didn't include it here,
No.
but you did include it there.
No.
Let me ask this question. The reason we backed off of the statement in what we had in our original document to what it is now is we didn't think we could defend that.
No,
I think Mr. Commit and Tim were mostly worried about the possibility of going too far and losing our grandfathering.
Yeah.
They didn't want to veer too
Okay.
far away from Tim's administrative comments over the years and the way we've treated it all along because they were worried about that June 2011 grandfathering.
Where
That's
the state
exactly
came
right.
down on us.
So,
Yeah.
so as I said, we debated this. So it's not, and whether this would have been okay, but it's adding verbiage to, this was the linchpin of our defense that we had this land use. And if we, this use definition, if we change it too much, we're concerned that people could then bring up, the red flag.
History.
Yeah, and whether that would happen or not, or challenge.
It's a defense, though, right?
It's a yes. So we tried to deal in other ways in here, and
We like it. I mean, I think it was more appropriate way. But now, if it makes it so you can't defend it when you have to, then I think you have to back off a little.
Well, I mean, it's the opinion of
with that.
it's opinion of the attorneys when you're going to get different things. I had to pick somewhere to go on this thing. And I felt comfortable. We wanted to be conservative enough so we didn't lose the vesting, but I felt comfortable because of the other definitions, transit and transit occupancy, that really explain what that is. And if you put that all together, you can follow the logic in that. Okay? So, I mean, this may have been fine, but we didn't want to set up the red flag. I mean, and I think the other thing I want to state is no matter what we do here, there's a lot of money involved in this. We could easily have a challenge somewhere along the line, and I'd be very surprised if we don't. But
And the legislature is still shifting and moving.
Yeah.
2015, I think we're going to see a lot of legislation. Representative Mayfield and Senator Altman were very interested in what they heard at the legislative session on December 5th. In particular, Mr. Commit made a very strong statement about how much trouble people are having. And then we had a citizen from South County on South Bear Island who came and did a fabulous presentation that really encapsulated what he and his two neighbors have been going through with one of these in the county. And of course, the county doesn't have any of this kind of prohibitive language because they chose not to go in that direction.
In fact,
but
they
the
put
city's been
permissive
trying,
language.
the
That's
city's
right,
been
they
trying
did.
very hard to maintain our grandfathering and hold the line on these vacation rentals. So there's a lot of posturing that's going to go on the next 6 months. It'll be interesting to watch.
Could I, summary is that it's more important to protect our grandfather than it is to be aggressive in our language? Is that what you're trying to tell me?
Yes, if we're too aggressive, we think that crosses a line.
And we
that
lose the
makes this
grandfather.
easier challenge.
Yes.
Which is more valuable than the
Yes.
aggressive language.
Yeah.
Flagler County wished that they had grandfathering
Yes.
language.
And as I said again, that guest house and transit courses is very important. That's what kept us in the ball game here. If we didn't have that, we would have a difficult time. Because then we're just relying on, there's so much discretion involved. But we had that language, and we felt that's why we're still stick with it. We didn't want to, we did a few things, but I think these other changes that we'll get into really expand on some of those terms, and I think without changing it, because I'll tell you, when I was at the hearing with the judges involved had no problem. They understood what transit meant. It wasn't many days or, months. It was pretty clear what a transit was. It was short term. You can read the dictionary.
Well, actually, when this whole brouhaha came about, when I started looking at the stuff that was going on across the country defining transit, it was always 30 days. All the states and cities, everything was 30 days across the country.
That's a pretty uniform thing. Now, that it's involved, that's exactly right. And that's what...
30 days max.
Yes, 30 days.
Right. Or above. Right.
Above. You have to have at least 30 days or a calendar month to do that. And again, I had my opinion letter that was used that spelled out, these are being reaffirmed by what we had in that opinion letter, and goes into a little more depth, which is good, relying on the state definitions in some of these cases. And we feel that is a more prudent approach to do, a more legally defensible approach. We have to get to it.
Do we need to define short-term?
No, well, transit is short-term. You'll see that we'll get down to that 30 days is really right in here. Okay. The term occupancy we decided to leave out. There's other complications with that. We don't think it adds to it, so we had number 3 delete that definition. The next definition is transit, a guest, and transit occupancy. So now we identify those transits that are up there in the guest. Okay, so you got a definition for that. The next one is the transit occupancy. We're suggesting we use the language in number 4 on that page, this change. It covers the same, it's just worded differently. Any occupancy, and I'm going to read it because I think it's very important. Any occupancy for which it is the intention of the parties that the guest occupancy will be temporary. This is a rebuttable presumption that the occupancy is transit when the structure, building, dwelling, accommodation, or portion thereof is rented to guests for periods of less than 30 days or 1 calendar month, whichever is less, or which is advertised or held out to the public as a place regularly rented to guests for periods of less than 30 days or 1 calendar month, whichever is less. You see how this all ties together now. We picked out a few terms in there and, expanded the definitions, and I think it pretty well states. And this, again, follows exactly what I did, followed up on my opinion letter. So we're not, in that opinion, when I came here in 2006, we were following that 30-day thing. And I can tell you we did some code enforcement cases back in early 2008 and letters on that 30-day rule. So we feel that that's been our historical application.
That particular definition, transient occupancy, is probably the most important definition in this. And
I believe a lot of the language here that the transient occupancy, the alternative, this comes right out of the Florida statutes too. So we try to tie it closely to the statute, the wording and the definitions, because that's what we were relying on when we did the 30 days in my interpretation letter, in which we have historically. So we're trying to keep an even keel that we can show, we've been doing this all along. Now we're just clarifying this so somebody can't say, well, gee, I didn't know that. The ordinance doesn't say that.
So it's interpreted one way and then the other way. Yeah. Yeah, I like that.
The next one is the manufactured home. These come right out, and manufactured home or park, so these come right out of our floodplain regulations, so there's nothing new there. We just stuck them up in the front because they deal with, we do have some manufactured housing projects in the city, so this is the term you use. And for people, I think, that don't understand, manufactured housing is not modular housing. Modular housing is just like regular housing. Manufactured housing is a vehicle, essentially. It's under
it's a license. That's what
the licensed DOT. Okay, so. And some people get that confused.
And it's used otherwise in other places.
That's correct. And the old ordinances.
When you're looking legally, it's one definition, but when you're using in the home building industry, it's different.
That's correct.
Connotation.
And the next definition is marina. I just cleaned it up a little. Probably could use a little more cleaning, but I cleaned it up. That whole marina section in the code needs to be worked on, which I told Tim Gravenauer that we'll get to one day. On his thing.
Did you want to include docks in there?
Oh,
you've got slips
yeah,
and
we could
moorings.
do. Yeah, that was one of the minor things I was. Yeah, we'll put docks in there.
When
Yeah.
somebody moors in the city for a period of time, how does it relate to this ordinance when there's city marina and they're...
There are certain we have
Yeah.
code provisions dealing with
It's
moorings.
covered separately?
That's covered in a separate.
Okay, that's
Right.
all I need to know.
Yeah. This gets to the land use
Right, I
itself.
accept
Okay.
that.
All right. We got rid of mobile homes, I said, because we have the new definition. Mobile home park's been eliminated, mobile home subdivision's been eliminated. We got rid of modular home because that's treated, there's no difference between a modular and a regular construction home. So we deleted it. There's no necessary, and I don't remember where in the ordinance they even used that term, but they had it in here. So, multifamily residential structure, again, we put the residential use of the building. That was missing from our code. And the last one is we were trying to go, again, this was being a little aggressive. We tried to define residential use. We decided to leave that out. We think the other things will cover. If you look at our definitions of dwelling unit, family, and all, we think it's covered. And this expands it again, and we're very concerned that it just raises other, flags that we don't want to have to deal with. So that basically is all the changes we're talking about.
I just wanted to mention one thing, too. I think I told you this at the last meeting, but maybe not. The final language that got approved by the state legislature last year about vacation rentals stated that a local law, ordinance, or regulation may not prohibit vacation rentals, may not regulate the duration or frequency of vacation rentals, but it allowed other regulations to go in. But those were the three things: you can't ban, you can't regulate the duration, and you can't regulate the frequency. And
Right.
frequently, those are the ones that you really want to regulate. You ask that poor guy down on South Bear Island, he would love to be able to regulate that. But then it retained the language, this paragraph does not apply to any local law, ordinance, or regulation adopted on or before June 1st, 2011. So that's where we have Tim's historic view of the 30 days still in place, and that's what we're struggling to keep in place.
And if you notice, if you read my staff report, I had nothing better to do in life.
We did, and we do it better.
But I concentrated on that duration. To me, that, because if we were to lose the vesting, then we'd be in the same place as Flagler County, having to go through, how do we want to regulate, and that means we'd be regulating all sorts of rentals, okay? But I concentrated on what those problems are, and having been in the Keys, that's exactly the issues we had. That you got a bunch of strangers there. It can, in most cases, in a lot of cases, it may not bring instability, but if you get a bunch of people running it like a hotel, and under the state law right now, that preemption, you can do it 1 hour rentals.
Really?
Oh, yeah.
Yeah, I've seen that.
Nothing precludes that, because you can't, as Peggy just pointed out.
No duration or frequency can be regulated, and no
so
banning.
you can imagine what that brings.
Let the bridal party go there for the hour before the church, and
Yeah, so you can see that this is very important to us all, and I mean and the state hasn't given us a lot of leeway, and we want to defend ourselves here. And clearly, I point out, the city council, that's why they wanted to move on this, or really want to defend the neighborhoods on this. And we get this ordinance through, my staff is going to begin its enforcement on it. And they want us to comprehensively enforce it unless I'm told otherwise, which is a little different than we've done in the past, which we were mostly on a complaint basis.
How are you going to enforce that?
Well, we'll set up a system of how we'll identify the low-hanging fruit will be the people with permits. I don't mean to laugh about it, but I mean, and that's why I'm a little concerned about the state going in there and they won't need state permits, so we won't be able to get a list of who they are. Now, the ones that have multiple ones, my understanding, it's more difficult. You almost need a public records request. The ones that are just single, like have a single home or something, it's easier. So that's one of the things we'll look at. We do the internet. A lot of times so that's how we start the thing, or we'll work on complaints too. But we need to be we'll have to be a little more aggressive on this. Now, whether I have the resources, we're going to have to see how this plays out. Yeah, and that is.
Does the city have any responsibility at all to licensing these places? Collecting bed tax?
I won't. If they were legal, In fact, the Carrolls didn't have, they didn't have a license, if you
Right.
all recall that. Well, they tried to come in and get a business tax from me, and I said, no, because you're not a legal use, I'm not giving you a business tax. Okay, because I'm not about to undermine our position that it's an illegal and it's not. So these uses probably don't have that. We're not going to give them a business tax if they're not legal. So, I mean, there are different ways we're going to look at this. The other thing that's concerned with, and particularly if the state isn't regulating them, is going to be the bed tax. You know, if it's 6 months or less, I believe 6 months is good. You got to be paying bed tax when you do that. Well, these.
No, they don't want you.
If they can get away with it, and the less oversight they have, they're not going to be paying a bed tax. Now, the ones that have pull permits generally paying bed tax. I shouldn't say they weren't doing that.
What about, fire and safety inspections?
I was just going to mention that. That was one of the things
Yeah.
that they raised at the, in the webinar on Wednesday, that one of the things they're really concerned about is safety, fire, carbon dioxide, pool, whether the pool is appropriate, evacuation for hurricanes and storms, communication with the guests who are there. It's unregulated.
Yeah, it's
Unregulated.
Sure, yeah, it's totally.
unless you have a house
It's
in
not
Key County
it's
Beach,
not under the
Florida,
hotel motel rules.
where they're
Where?
Key County Beach, Florida, making me.
Now, that's amazing. I did not know that.
Yeah, but they have a rental ordinance in place, so they've always had regulations on that.
And we couldn't insert those requirements in here, could we, for
Well,
Vero Beach?
what we're saying is, and there's some legal issues that she just brought up, but I
Yeah.
mean, if we were to lose the prohibition thing, we would have, the other way would be to, like Flaglerstone, we would start to look at regulations to regulate these type of, well, we'd be probably regulating almost all rental uses, because I guess if we unfairly picked on them, it would have to be, we'd have to look at that.
Then you go to regular homes and things like, and that'd be a nightmare.
Well,
What about
that's-
the hotels that we have? I mean,
Yeah, but there's a totally different oversight on that, isn't there? In the
What's that?
Fire, with the regular hotels in the
Oh,
city?
yes, no, they're not talking about taking that, deregulating that, at least I hope not. But they do have building code requirements because of occupancy.
Is there any correlation between the amount of complaints we get and the price point they're at? Is there some relationship there? There's the higher end units that are doing this under the table versus the more lower end units.
Well, my guess is we got more complaints in the higher end.
That's what I kind of wonder.
Yeah, there's no doubt
They're more
about it.
sensitive to the changes that occur there
And
than
that whole
somebody
thing-
living in a different
right.
plane.
And when this whole thing started on Sea Grape, I mean, you're in one of the more upscale neighborhoods in our community, and when you have a bunch of people showing up, that like 20 people showing up with cars and garbage all over, you kind of stick out like a sore thumb in the neighborhood.
and noise all night, yeah.
And, yeah.
Part of it's the garbage.
Oh, and it was, yeah.
Oh, yeah.
They leave on a Saturday and there's not pickup until Monday or Tuesday.
Yeah, well, and that's illegal. See, you can't, our ordinance, which needs a little refinement, you can't leave it out but 5 o'clock the night before the pickup.
Right.
Tim, I have a question on
Yes.
the multiple family structures. It says the residential use of a building or structure containing 3 or more dwelling units to be occupied by one family per dwelling unit. My
Correct.
question is, for instance, the home that is very familiar with code enforcement on 16th Avenue, the big brown home
Okay.
that does have garages, or at one time was used as garages and sheds, are now housing people. Is that considered
Well,
part of that structure now?
If they're housing people, let me ask you, have you talked to my code people?
I'm pretty sure code has gone there before, many times
Well,
before.
if they're out in sheds, they're obviously, those things were never approved to be for habit,
There's window units, air conditioner
Okay.
units hanging into the
Do me a
alleyway and
favor,
all
if
that.
you would do you have the address? I want to look into that. If that's going on, because we need to play hardball with that. That's not good for the neighborhood, and I can,
Right.
But they would normally have to, they could be creating independent living units, and we get into a real problem. We have people, and I can tell you, some of our older neighborhoods have a lot of that are illegal. But it's difficult to go after them. I just got in fact, in Osceola Park, I just got they just bought their house, and the woman who sold it to them, she had an attached garage that we'd approved to put a bedroom in there. Well, she went a little beyond that. So went and put a full kitchen in there and had it renting out, and they didn't use, when they bought it direct from the owner, and they got caught. And we caught them. It was brought up to us, and I had them remove a bunch of stuff, and they entered into a compliance agreement with us that basically allowed them to lease the thing out, but I had to have a copy of the lease, and it had to be under the circumstances that it had to be run, that this person, whoever they leased it to, had to have use of their laundry facilities, their kitchen facility, just like a regular house. We don't try to get into relationships and all that, but how the place is run, and that's what happened there. But we know there's some other ones in that community.
Well, there are a few in original town
But
itself.
I would like to, this sounds fairly egregious, and I like to look into that, okay? And any of these, when you know of something that's that egregious, we need to really get in there. But we do have conversions that, we get them every now and then. We'll get somebody's converting duplex to fourplex.
How far back does it go on situations like Linda was talking about, till it's considered grandfathered before permitting?
There is no vesting from the statutes of these kind of cases.
Oh, really?
So a garage.
We do take into account. Sometimes, I'll get a call. Well, you can't have a duplex on here. Well, if you look back in 1950s or something, it showed as a duplex. It was probably approved and the zoning changed. But in most cases, if they've done something, it comes back to haunt them. And now with the mortgage company, the banks, they're getting we get people all the time coming and removing stuff because people had done a lot of things without a permit, and they're not giving them mortgages.
So the conversion of garages without a permit is...
You need a permit to convert a garage.
Well.
And clearly if it's turned into, that's not...
Okay.
Would, Tim, would the city then, if they turned a garage into a home, and if there's a meter can on it, then the city would not have put a meter can on there if they hadn't got a permit, is that correct?
No, we won't give them a meter cam. I'll get a call sometimes from electric that somebody wants a meter cam, and we take a look, and we've had all sorts of, we stopped that. We have a good, obviously, the electric company being part of the city, we have a good relationship. I don't know how with FPL would be the same. That we would not allow them to have another meter.
Okay.
In that situation, yes. And a lot of times they're doing illegal electrical work to do all this under the, it's a tough situation, but you deal with it.
Newer situations where you have new communities, a lot of that's avoided because the history can't be there for it, so they can't go back and claim it was 1920 this happened. Okay, when you get, because in the community documents prevent a lot of that stuff. Also gives you a second hand helping you with your situation.
Some of these that go back in the 40s and earlier, you've got problems. It's hard to figure out, and we don't try to be too heavy-handed on these things. But
it's very typical.
Clearly, when you see, it is typical. It's not unusual, we, where we can, we try to work people through. Sometimes they can work through these things. They get an after-the-fact permit. They don't have to tear it down. Get an as-built, get an engineer to certify it works. Other cases where they've created these additional dwelling units, we start removing them. The problem you get into, you got families in there, and it gets to be a little tougher when you're dealing with.
You didn't have recorded deed restrictions created by an association back then for a lot of those communities.
Well, not for those kind of things. They didn't restrict. There were other things that are not legal anymore.
There are actual restrictions that have been obliterated by Florida statute because they're just against public policy about which types of people can live in a neighborhood and not. And if you look back in the old deed restrictions, you'll see some of those from the 40s and 50s. Very interesting in a title search.
But even with deed restrictions, a lot of times if they don't have a homeowner association that has an active, and Ms. Manus can tell us that, they don't. If nobody tries to enforce, then the courts aren't going to. It's gone after a while. So, But even a homeowner association isn't necessarily going to protect you a lot of times. These cases. We get a lot of calls.
Especially if it's a voluntary.
I get calls from from gated communities all the time on vacation rentals, and we'll enforce where we can. Even though they should be able to do that so in their ordinance too, or not ordinance, in their covenants.
Tim, could you give me a little history over the last couple of years since this issue came to the forefront as to how many short-term, in your opinion, how many short-term rentals are now taking place or have
Well,
taken advantage
right.
of
Okay.
the ruling?
Well, yeah, it's a hard number to do. I think, and I might be wrong. I think I had Melody Sanderson, one of my code people, run the numbers on, I think there were like 70 permits out there, something like that. And these are the ones that went through some legal process. I may be wrong. I'd have to check on that. But we've identified, 30, 40 on that. And that's just basically on a complaint basis that we would get, or somebody's been advertising and we pick it up and then follow up. And normally what we've done is we'll send a letter out to them saying, look, you're in violation of the ordinance. And usually they'll say, we cease and desist, and we've not had an issue after that, at least one that we could pick up very readily. You know, this is very difficult because what things are done behind closed doors, we have to have some
Reason to go there.
yeah, and we can't get warrants to get in these places generally. And we wouldn't do, that's getting a little heavy-handed.
So you think it may be double or triple what you're actually aware of then?
Oh, yeah. I would say it's bigger than that, and I know of some personally that are members of the community that I haven't had a complaint on, but they would probably be under our radar. Shall we say upstanding members of our community.
And if you just look at Airbnb, the website
yeah.
for Airbnb, you'll see a lot in
Yep.
Indian River County, Vero Beach area.
Yeah,
Very popular website.
A lot of times it's hard to figure out where they are because they don't give you addresses necessarily. I mean, say Vero Beach area, but so a lot of them, and then a lot of those may be in our condos. If you're in a C1A,
Yeah.
it's not an issue because those can be transit and all that, and that's how that's looked at. Now, if they're run like a hotel, there's density issues that we get into, and I've dealt with on several of the hotels, like Vero Beach Hotel and Spa. They were talking about, can people get a homestead? No, because we allow 15 units an acre as our maximum density in there, but 30 rooms an acre. So you can imagine, on that kind of thing, and they have requirements in there. They won't let them do it, but every now and then they'll come to me and ask me. No, I said, well, if you want to get approval that way, you got some parking issues and other issues you have to get rid of.
Yeah.
So it's kind of interesting that way.
Challenging.
So unless you have some more questions, Mr.
A lot of work
Chairman.
went into this. A lot of work went into this. It's going to go to council then next.
Yeah, it's going to be
beginning
on the
of
6th. So
Okay.
what
That'll be
I
public hearing for them.
what I would like asking you today, if you wouldn't mind recommending approval of this with those changes we had, and I will look into that, the daycare.
Add docs.
And changes on that, okay?
Add docs.
Because I
Mr.
think-
Chairman,
and
we
the docs
also-
will go in there, and they'll be smart.
Mr. Chairman, we also need to open it to public hearing
Oh, yeah, I'm sorry.
technically.
Legislative, right.
Before we have our vote, then I'll open it to public hearing. Seeing nobody coming forward, I'll close public hearing. And comments from the board, additional comments you'd like to make?
Nope.
I have one. I only have one disappointment, and that is that I believe that our city council is in a miss. And if they seem to set the rules for us, and yet they don't follow their own rules, I think I would recommend to them that they follow the proper procedure next time and bring it to planning and zoning first and follow up with their approvals and first readings afterwards. And I think that kind of sheds us to look like a rubber stamp. And if they want a rubber stamp, then they should remove me from the board because I don't expect to be that. And I expect the proper procedures to occur by them as they expect us to go through proper procedures. And that's a personal opinion. It doesn't necessarily represent anybody else in the board. And I hope I didn't offend anybody, but it's the way I feel. And I think if we are an important, valuable board of the city, they should treat us as such.
What was their rationale? It was because...
I believe they wanted to move quickly on this thing, and
Before the legislative session?
well, I think there's a lot of pressure out there in the community to do something, and whether, they were told that they're going to have to come back to you all, and,
Sometimes they do parallel tracks.
They do parallel
I'm not
tracks.
sure
It's
if that was the case this
But
time.
I can understand, but this ordinance has already been changing a lot since they saw it, so, But I understand your concerns, Mr. Chairman.
Tim, at that public, if I could just ask one more, at that public hearing, previous public hearing at City Council,
Well, they didn't have a public hearing.
there wasn't.
No, it was
The
a first reading.
First reading, no comment
No,
from the public?
they allowed the public to
Please
talk,
speak.
but it's not a public hearing.
Okay.
Okay.
Well, along that line, was there opposition or support for moving forward from the public or against? And what do you
There was no
anticipate?
real comment on it.
I don't think it was any comment.
I
I don't
don't
think there was any
remember.
comment at all.
No, and
There
Tammy
was
said-
quite a bit of comment at that September or December 5th legislative session hearing about vacation rentals. A lot of comment back and forth, which was very interesting. If you get a chance to see that, I think it was recorded, wasn't it, Tammy? It was televised, so it's a very interesting hearing.
Yeah, and it was very good. I think, we had Wayne made comments and
Mr.
several
Commit,
citizens.
the mayor spoke,
Yeah.
a couple of citizens. There was some back and forth with public comment as well.
The reason I asked that question is because we have no public here today.
I know.
And this was advertised.
I know.
And people spoke to me about it, there was a good bit of knowledge that this hearing today
This
was
is what's
taking
going on,
place.
yeah.
So I'm quite surprised that there's nobody in the audience.
Yeah, so,
Actually, the advertisement didn't specify short-term rental.
Didn't.
It referenced the code.
Well, yes.
Clarification and updating certain text and,
We're not trying to conceal it if you read anything, but we weren't trying to wave a flag, a red flag, to the whole.
It was a general review. Is there any further discussion? Then I'm looking for a motion.
let me just think for a minute. I think, Tim, and Peggy and Wayne, I think you've all done very well strengthening and clarifying what's necessary here. I wish we could go a little bit further, but then that threatens the whole code, doesn't it?
Well, it threatens
Yeah.
it, particularly
Yeah.
that portion of the code, yeah.
Right, yeah.
all right, I make a motion that we accept this and pass it on to the city council.
Yeah.
With
Okay.
the amendments I
With all
recommended.
the
Yeah.
as well
amendments
as-
that are
In
recommended.
the daycare, I will put amendment if we need to, and I'll put docs in there.
And
Okay.
Docs, yeah.
I had that already. That was one of my minor edits.
Do I have a second?
I'll second.
Okay.
Okay, third. Okay.
It's been first and second. Further discussion. My only discussion I'd like to bring forward is that this may not be exactly the way it comes out to City Council. I think these modifications may precipitate further modifications to it. And I think, in general, what we'll be trying to do is add as much teeth to it as we can without stepping over the line. And I think we are generally consensus, I feel it anyhow, that's okay with us that occur, because we're in favor of this in a pretty much now the current term is bipartisan way, okay? To move forward with this, so.
I do, let me,
Sure.
see, this bill that's being introduced, Peggy, this is the one that is looking to take power away from us completely?
This was just filed yesterday, and I haven't had time to review it closely. It was provided to me by Susan Trevarthen, but just on a quick glance, it did seem to be taking away the requirement that these sorts of establishments, vacation rentals, would have to pay a state tax.
Okay.
But this is just the first volley.
Sure.
I think there are going to be many bills filed. I had a feeling that the representatives and senators that we had here that day on December 5th were probably going to be taking a really close look at doing something. So we'll see. It'll be an interesting
On which side of
legislative
doing
session.
something? Did you get a sense?
Probably on the side of backing up that poor gentleman who was in here talking, but you
Mr.
you
Conway?
can't tell. There's a lot of
Hunter?
legislative pressure. There's a big lobbying group from the vacation rental industry.
I know, that's
So-
what prompted my question. Yeah.
And that's easy for a lot of people to acquiesce to because it brings revenue into the state. And one of the things we grapple for is more revenue. And so it becomes easy to get on board unless you have some specific defense, and that's our communities and our neighborhoods, what we have to defend here. So we have to push back, I think. And
I mean, if you follow that logic, why not allow you to do retail and other things so you can make a buck?
Well, and
I mean, it really
Yeah,
gets to.
right.
They discussed that at that webinar yesterday, or Wednesday, yesterday, and they said that the early premise of the legislation was to allow homeowners to rent on short-term basis to mitigate the effects of the economic recession. So there was a definite reason behind it back then when it was put into place.
Well, that's in the past.
Things have changed a bit now, and there's a lot of pushback. So we'll have to see what happens.
Good. Is it coming from all around the state?
Oh, absolutely.
Good. Good. Okay. So I think that you've made this as strong as you can to clarify it, and you probably look a little more too.
Can I call for a vote? Is it just that we have, it's because
Voice?
we have voice vote?
Roll
I'll do a roll call.
Roll call, okay.
Yeah. Mr. Cahoy?
Yes.
Mrs. Hillman?
Yes.
Mrs. Manous?
Yes.
Mr. Polinsky?
Yes.
Chairman Laufer?
Yes. Thank you.
Okay. Thank you. That's a lot of work.
Thank you, Tim.
Oh, hey, I got a lot of support here. Good
Yeah.
team.
Most of you.
There's always somebody, there's always
Mostly
somebody
Mr.
carrying him,
Command.
you know?
Well, I'm in a good team.
Thank you, Wayne.
Yeah.
Yeah.
The next thing we want this on our agenda is the annual report. And I think you've all had a chance to look at that.
I want to apologize. There are a couple typos on the second page on where I have recommend, should be recommended in the past tense.
I didn't catch it, sorry.
Yeah, well,
What number?
I read it.
What number?
oh, it's on the second page. You get down toward, above the bold print, those two,
Oh,
where it says
recommend.
recommend approval, it should be recommended approval.
Past tense.
No, I didn't bring up our ill-fated ordinance on changing the membership, so that was left out.
Okay. Some of us weren't here for that.
Yeah, I know. I wish I weren't.
Okay.
About item number 1 under major milestones,
Yes.
isn't that a 15-unit hotel? Rather than 16?
Yeah, let me check it. They changed the number. And
They did?
Yeah. Well, no, I think you might be, I
That's
think
the
you're
one on
right.
Royal Pond?
I think it was, I was taking it off.
It says
the-
15
Yeah, I
units.
think it's 15.
Yeah.
I think they changed it. This was when they submitted, I was looking at how it was earlier stuff, so I could have missed that. I'll check that. Okay. That's a good pickup.
That was a busy year.
Yeah.
Oh, this is way busier. We only had one major the year before.
It just didn't feel like this.
I wonder what that was.
I think I'd like to get, before it's submitted under my name, Tim did about 95% of the work. I would like to recommend that, is there any changes or modification other than the one number there that we need to do and a spelling correction?
Recommended
approvable?
needed to go in there twice.
Twice, well, I
Yeah.
saw it too. I think he
I'm
mentioned.
sorry, what's that?
Recommended twice.
Yes, right.
Okay.
On the focus of the efforts in 2015, incorporating the completion of the ordinance that we started this year to incorporate the wetlands protection.
Yeah, and I still need to work on that. The biggest concern I had, and the chairman and I discussed this, is that I don't want to oversell what we can do next year. We are going to be under a lot of stress just doing this comp plan, and I got a year to get that comp plan done. The whole thing's got to be redone, and plus there are other things that need to be done. But I do think we need that wetlands and so I need to work out how to do that and get maybe another staff member, which I should, involved in getting that thing done. I think the thing about the wetlands thing, it has a lot to do. It's integrated with protection of the lagoon.
Absolutely,
So there's some good things that we can do in there, and I think I've got my person who I'm going to volunteer to do that.
Beyond that, last year, I believe it was in the month of January, I believe we kind of prioritized what we had available, and I would recommend we put that, Tim, on our agenda for the first part of the year. And we don't know all the issues that come up, that's obvious, but we can decide what we'd like to do and prioritize what we do know, and then we can kind of chomp it a little bit.
We had priority, high priority.
Right.
I know.
And we modified it actually during the year. We made some changes to that, because some of it dragged on forever.
That's a good
And we had
roadmap.
to get,
Yeah, I'll put that back together again because we have some stuff and we can filter through that. So, again, I hate to keep putting stuff that we think we can do and we keep falling back. I don't want you to think, I want to have something that's realistic that could be met, and I don't oversell what we're capable of doing.
What
because-
about the septics? That's a huge issue now.
Well, they're moving forward with that
Okay, is that-
ordinance.
that won't come
yes.
to, will that come to us?
No,
I
there
don't
isn't
think it
going to be a
will.
need. That was handled through,
Public Works.
and Peggy was doing a lot of work in Wayne on that.
It was, it
Yeah.
went to first reading, public
Yeah.
hearing, it's passed, and
Yeah,
Rob
that's what I
Bolton
thought.
is moving
Yeah.
forward, so it's very
Excellent.
exciting.
Yeah, they were going to have us involved, but they didn't really need to.
And eventually, we
Yeah,
had to
okay.
go to the governor to get that issue resolved, that legislative issue
Yeah.
resolved that kind of got dropped last year.
Right.
And the governor basically told his two departments to get along. And so then we were able to move forward. So it's really a very exciting project.
Yes.
Jim, has anything come back from the state on the comprehensive plan
No,
for
yeah,
original
when I was
county
getting to
yet?
planning matters, I was going to
Okay.
say, no, we've got no reviews. In fact, at the hearing, and Ms. Hillman, you were there at the hearing where Community Church brought up, so they never came back to me, so I think they're fine on that. The one thing I want to point out, and this is not germane to this, is I'm going to recommend a change on one of the policies in there, the date of doing the report, because of the comp plan. I was going to have it on July 15th to do the analysis of I was going to do it have it toward the end of the year, because we're going to try to handle some of that during the comp plan. I don't want you to
Okay.
think I thought it was just overcommitting, and I really want to get this comp plan before I retire from this place, that we have a comp plan in place that's not 30 years old or so. Yeah, jeez,
Don't
that
plan on
means nothing.
retiring anytime soon.
Hey, with 2 mortgages, you don't retire.
The last comment I made, I think the board should be congratulated. I think we got a lot done, I really do. And I think
there's a lot.
that the city, I hope they appreciated our effort, because I think they've done an
Staff
outstanding
does.
job. Okay. We need just an approval from the board to say they're in agreement
just,
with this?
Okay, so moved. So moved. Forward this
And we'll
along.
make those changes.
Okay, and will they accept this so it's presentable to the city council then? We need to vote on it? Is it an official vote? All in favor, say aye.
Aye.
Oppose? Thank you.
Thank you.
Oh, thank you. Okay, well, I already reported on one thing in the planning department. The other thing is we won't have, obviously, January 1st is going to be a holiday, so your next meeting wouldn't be till the 15th, and I don't have anything yet on the agenda.
Honey said she was coming.
Pardon?
Honey said she was
I'll
coming
be
on the
here on the
1st.
15th. Yeah, I'll be here the 15th.
You told me before you'd be here. Okay.
So unless you have some specific questions of me, I don't have anything else to add other than, hey, happy holidays.
Happy holidays.
Anything
Yeah.
new on
Merry
the
Christmas. Merry
newspaper boxes?
I haven't gotten to the newspaper box, I'm sorry.
Thank you. Richard, right there. Can you read the advertisers and newspaper box right there? It's not going to go away, Tim,
I know it won't.
no matter what, until they put us all in a box and put us out there. It looks terrible, and it's not representative of our beautiful city.
Well, okay.
So our next P and Z meeting is January 15th.
15th, yes.
Yes,
Okay.
unless we cancel it, but right now, that's what we're...
Okay.
Okay, and you're going to prepare like a high priority kind of thing for us to
Yeah,
go
let
through
me
this year?
yes, let me go
Yeah.
through what we did before, and I'll try to put something together for that.
Right.
Okay?
Okay,
Is there any other board member matters?
don't believe so.
I would maybe Linda could just make one comment. I'm asking you, Linda, about Osceola marker. I thought
The
I heard it was well
Osceola
received.
Park marker, that was fabulous. The short time that I was there, because I did have to go to work, it was just beautiful. There was a great turnout. There were a lot of people there. Vicky Gold later emailed me and felt very bad because she neglected to mention Tim McGarry's name and his staff. But as I said to her, there's many times where you're just rolling off names and some are omitted, not on
Intentionally.
purpose, intentionally. But Tim and his staff did a fabulous job on Osceola Park and Original Town. And the Historical Society, the marker was just beautiful. It's fabulous. If you get a chance to go down and see it, you should really do.
I'm sorry I missed it.
Yeah.
It was a great turnout. It really was. It was a special event, and it was just wonderful for Vicki Gould and Anna Brady and Tim and his team and the Historical Society. They did a great job.
Long time coming.
And that's the wonderful thing about those neighborhoods over there. The people
They
like
care.
Linda and Vicki and Anna that really get involved in it.
And
that's what makes us.
I hope to work with Anna in the near future.
Oh, that would be great.
Trying to get something similar done for Original Town. I think it would be a great thing for us to get
Now that
that
you've
done.
got your original town.
Our little Original Town, yes.
Agreed.
The original Town. Thank you.
Seeing nothing else on the agenda for the day, I'm ready for an adjournment. I wish everybody a Merry Christmas and a Happy Hanukkah, and have a wonderful holiday season, okay?
Okay.
All right.
Thank you.
Bye.
Thank
Thank you very
Thank you very
much.
much. Happy holidays.
So civil and get so much done.
Right.